Which business problem made you realize that you needed a lawyer? Story 1. Can I sue my business partner in small claims court? Hi, smart legal people. A few years ago, I became a partial owner in an online business that my friend started. We are a multi-member limited liability company, taxed like a partnership in Oregon. I and one other partner own 20% each, and the guy who started the business owns 60%. For a number of reasons, I need to exit this business and move on with my life. We do not have an operating agreement. I know that's stupid. Please don't beat me up about it. I tried hard for a long time to get everyone to sign on to one, but it never got done. I gave notice to both partners that I intend to exit about 2 weeks ago. The minor partner has accepted that, and we are working on a transition plan. The major partner, so far, has not responded to any communication. I assume he's frustrated and not ready to talk. All communication has been by email because we travel frequently and run the business remotely. Because he's a friend and I care about the success of the business, I plan to continue to try to engage him and structure my exit in a way that is fair to the business and my partners. My question: what do I need to be doing right now to make sure I cover all my own bases and do this right, considering that my partner is being unresponsive? Do I need to be sending certified mail, or is email good enough? Email with read receipt. Something else? What kind of timeline should I be operating on? I have many more questions actually, but I'm trying not to think too far ahead and take this one step at a time. The research I've done so far leads me to believe that, in Oregon, limited liability company members can remove themselves from a business 6 months after giving notice, but still retain economic interest in that business. Sort of like a last-ditch way to make an exit when agreements simply can't be reached otherwise. I've worked really hard on this business, and it's mildly successful, more than $100,000 annual profit. It's important to me that I protect my own rights economically while exiting the business in an upstanding way. There are probably a million ways this can go, and who knows what will happen next week, but what should my next steps be? Thanks in advance. P.S. I expect this to take some time to resolve, so I look forward to posting updates and continuing through the whole process here. Update first, a quick update. I hired a non-litigation business attorney to help me figure out what my rights as an owner were. He was helpful, but that didn't go anywhere. My non-responsive partner finally contacted me after months of silent treatment while I continued to run the business, and the results were disappointing. A few weeks ago, he decided I'm no longer involved in the business, removed me from our bank account, stopped making distributions, and sent me a generous contract offering the opportunity to return my equity in exchange for not suing me for something. His threats were vague. Now onto the show. So, now I've hired a litigation attorney who's the best and most expensive in town. I'll ultimately be following his advice, but I had an idea I thought I'd flesh out here before passing it by him, in case it saves me some time. Read money. Discussing hypotheticals with him, it is assumed that as long as my partner doesn't buy me out, I am due my pro rata share of distributions any time they are made to other partners, and I am not obligated to provide any further service to the business. Buyout talks are going nowhere right now, so my thought is, can I just wait for them to make a distribution to themselves and then sue them in small claims to recover my share? Seems like it could be an easy way to make myself whole one little bit at a time and perhaps motivate him to have a more honest buyout discussion. It's unlikely my share of any distribution would be over the small claims cap, $10,000. Is this a decent idea for a remedy? If so, who would I name as defendants? The company? My 2 partners? All of the above. And how will I know if a distribution is made in the first place, now that I've been removed from the bank account? I know I'm entitled to inspect company documents, but not sure what I would ask for in this situation, or if I could believe the accounting records that are sent. Update: I have a lawyer, 2 of them actually, and I listen to them and do as they tell me. I come here because I'm slightly neurotic, and being neurotic with your lawyer is not a financially sound practice. Today, I have a brief update and another question. First, the update to entertain. For the last 8 months, My lawyer has been hounding the business lawyer for the financial records I'm entitled to have access to, and we were either led on only to receive nothing after many promises to deliver, or stonewalled altogether. Finally, in November, we filed suit against the business in Big Boy Court to receive injunctive relief, requesting the business records and legal fees, which we believe were due under Oregon law. The registered agent, my biz partner, evaded service until January. Then, we received no answer to the suit until the day after we filed notice of intent to take default. The answer was filed by a different lawyer, same firm, denying all allegations and claiming I do not actually have interest in the business. They also got in touch, a third lawyer again, same firm, at the same time saying, "Let's talk." "What do you want?" we said. "We want to be bought out." They asked, "Okay, how much?" We said, "Send the records over so we can tell you." They said, "Okay. Give us 2 days. We have them, but our admin needs to label them." They're running 2 different storylines, one officially in the lawsuit and another in what at least felt like an attempt to negotiate. That was 2 weeks ago. We've been hounding them again and are being stonewalled again. Based on the history of this case and my long-standing relationship with my partner, I'm no longer convinced they intend to negotiate at all, and our conversations so far are really just another attempt to delay. This morning it was uncovered that the business has altered some official documents to be very much not in my favor. My lawyers are friggin' pissed, and we're scheduled to chat next week about potentially moving to a contingency agreement, which brings me to my question. What do I need to think about before accepting a contingency agreement? I know the most basic things to think about: ultimate value of case, cost to pursue, and contingency fee, but I really don't know anything else. Are there other factors to consider? I feel like being offered contingency is a godsend for most because it removes the uncertainty of the cost of litigation. That's enticing for me as well. But I'm also not destitute, and so far, I've been pretty happy with how efficient my lawyers have operated. I feel like it's not a tremendous hardship for me to keep funding the operation, at least for now, and keep all the still uncertain spoils. Any advice on how to approach this? Update. Hello again, the legal advice subreddit. I understand you appreciate updates. I posted several questions and updates throughout my saga, but here is the most relevant original post, the important points. I was a minority shareholder in a small business in Oregon. I also worked in that business. I decided I wanted to no longer work in the business. The majority owner decided he didn't like that, so he fired me instead, froze me out of the bank accounts, stopped my distributions, and threatened to sue me to get back all the money I ever received from the business. That was scary and frustrating, so I got lawyer. Now the update, after spending months trying to peacefully resolve everything and getting stonewalled. We filed a document inspection lawsuit in November to compel my partner to produce all our agreements and financial documents, so we could at least understand what the heck he was doing and to figure out just how bad he was screwing me. My lawyer, who's practiced for 30-plus years, said he's never had to file an inspection suit before because in Oregon it comes with attorney fees. No one allows themselves to be sued for that because it's a big liability. My partner dodged service for 2 months, so we weren't able to get the ball rolling until January. He had a lawyer this whole time, but they never agreed to accept service, and then more stonewalling. We ended up filing notice of intent to take default. The next day, they filed an answer to the suit denying everything and countersuing for attorney fees, which apparently they can't actually get, in March. My lawyer's assistant was doing some routine research and just happened to find that the business filed amended documents with the state that completely omitted me as a member, owner. He was trying to erase me. My lawyer decided the best thing to do was to continue the inspection suit and file a new suit naming my partner personally for breach of fiduciary duty. That way, he could try to do as much useful discovery as possible under the inspection suit, where we could get attorney fees back and use all that discovery again in the individual suit where we couldn't. This is also the point at which he offered to represent me on contingency, which was a huge relief for me because he's expensive and things were escalating. He also credited the fees I'd already paid towards future costs expenses, which helped a lot. even though the other side was making no effort to resolve the problem. That really felt like a positive turning point because I think getting a lawyer on contingency for a business contract dispute is pretty unusual. I later learned my lawyer offered contingency because my partner pissed him off, and he wanted to keep turning the screws on him. He didn't want me to bail. I get the impression he's getting towards the end of his career, and just likes to work on cases that interest him now. Fast forward a few months, and we depose my partner. That experience pissed my lawyer off even more. I wasn't there, but reading the transcript was both sad and hilarious. My lawyer said it was the third most frustrating deposition he's ever taken. Oh well, guess you can't be first at everything. After the deposition, partner's attorney got in touch to offer a settlement. He was on his third lawyer at this point, by the way. It was a terrible offer, so we said, no thanks, but we'll do mediation if you want. They agreed, which is tragically comical to me. Mediation was my partner's idea, that I agreed to before any of this insanity ever started. But he changed his mind at the last minute, and I never heard from him again. We spent a full day in mediation, and at the end, accepted a mediated settlement when negotiations broke down. The settlement, once the contingency fee was subtracted, was not far from what I thought I was owed, so I was happy to accept it, and put an end to an emotionally draining 2-year saga. I often second-guessed myself throughout this process and felt guilty for suing someone I once cared so much about, but really, he brought it upon himself, and I'm happy that I stood up for myself, and am not spending the rest of my life asking, why did I let him get away with that? My ex-partner has a very strong cult of personality that served him well. He's very charming and can convince most people to do what he wants. I don't think anyone's ever stood up to him like that before, and it caught him flat-footed. The whole process was confusing because he never made a logical move until he was truly backed into a corner and was facing trial. At every turn I wondered, is this a trap? Do they have some epic strategy I can't see? The longer things dragged on, the more I realized they didn't. There was no strategy beyond ignoring me until they couldn't anymore. Though my bank account is much healthier today, I have to say the money really rings hollow. I lost a friend and a partner in this debacle. But it was obvious I was going to lose that anyway, so better to have the money than not have it, I guess. And I'm very thankful I found the lawyer I did. I probably could not have sustained the fight all the way through trial without a contingency agreement. I could tell he really loved his job, and I think he's a little bummed we're not going to trial. Story 2 original poster is fired over false accusations of sexual misconduct. Company says he can't sue. I held a management position at a company. I asked a non-management employee of the opposite sex to step into another room to discuss her performance away from other employees. She was going through a divorce and had made a few mistakes, and while I didn't want to embarrass her, I did want to make sure the mistakes were addressed. She acknowledged it and thanked me. An hour later, I was escorted from my office by security and was informed by my boss that a sexual harassment complaint had been made and proper protocol was to suspend me. I asked what it was and was told, we need to investigate. I can't disclose that. He assured me that it shouldn't take long, and if I wasn't guilty of anything, I'd be paid for the time out. I again asked what the accusation was, and was told that as there was an ongoing investigation, I was not permitted to know, but if they had questions, I would be contacted. I wasn't happy, but knowing that I didn't do anything wrong, I left the building. Later that night, I received a notification on my phone that my email password was incorrect. After 2 days, I called my boss asking for an update, and was told he was not available, but I would hear something soon. I began calling daily and received the same response. Finally, I received a letter in the mail, informing me that I was terminated for indecent exposure and soliciting sexual favors from an employee. The employee listed was the young lady I had pulled into the side room. I immediately called up my boss and was told he is unavailable and said to say the matter is closed. My buddy, the information technology guy, messaged me on Facebook asking what happened as he'd been told to deactivate my accounts. When I told him the whole story, he replied, "You took her into the X room." Dude, There's a security camera in there. We keep Y in there, so we always have the camera on. Sure enough, he pulls the footage and there I am, holding a pile of papers, pointing to them, and keeping my pants on the whole time. I left a message for my boss that the alleged incident occurred in a room with surveillance, and that I would be contacting an attorney and subpoenaing the video record. I received a call back 15 minutes later, asking me to please participate in a phone conference with him and Human Resources. The conference went as expected. They didn't realize it had occurred in a room with surveillance. They have a zero-tolerance policy that they have to enforce. You can't be too careful in this day and age. They regret that this didn't come to light sooner. They've already replaced me, and as it wouldn't be fair to terminate my replacement, as she's done nothing wrong, they don't have a job to offer me back. However, as a gesture of goodwill, they're going to pay me through my suspension, change my file so it reads that I voluntarily resigned, and provide me a good reference. I replied that wasn't acceptable. They made a false accusation against me, withheld vital information that I could have easily refuted, refused to take my calls, and completely failed in their own investigation by not checking video footage that would have immediately exonerated me. They asked what I thought would be fair. I told them they could immediately terminate the employee who made the accusation and either give me my job back or pay me out 1 year's salary, in addition to what was offered. My boss said that he could not discuss another employee with me, and that neither of those options are feasible. The only options I have are what he already offered. I replied that the options I gave are the only way I'm not going to sue the company along with the employee. My boss replied that I signed an agreement when I was first hired, saying I would take all disputes through arbitration and that I waived my right to sue the company. I do not remember signing the agreement, and I have not seen it, but it apparently says that I will take all disputes to arbitration. I will bear the costs of arbitration, and that I will accept the decision in arbitration. He stated that I will not fare any better in arbitration than he's already offered, and I'll be out the money to cover the arbitration. I feel like I'm being bullied here, and don't think he would have scheduled a phone conference with such immediacy if he didn't think the company was vulnerable to a lawsuit. I'm waiting on a callback from a few employment attorneys. Do I have a case? Am I wrong to feel that this is unacceptable? Update 1. Quite a bit has happened in the last few weeks. A friend of mine at another company, after hearing what happened, told me his company had an opening. I applied, interviewed, and at the end the manager asked me what I liked to be called. 2 days later, I got a call saying they'd gone with another candidate. My friend admitted to me that he'd gotten some flack for recommending me. Apparently, Human Resources had worked with one of the employees at my former company and called the employee to ask what the deal was with me, to which the employee responded, he got fired for sexually harassing a subordinate. I think he's actually being charged criminally. I'm literally crying as I type this. It's a nightmare that won't end. Long story short, I lost my temper, called up my old company boss, wouldn't get on the phone with me. Had an attorney draft a letter of demand and send it off. Had another phone conference scheduled. They once again regret that an employee provided a reference outside of the prescribed channels. The employee was coached on the proper way to handle such requests. My attorney informed them that in addition to wrongful termination, we would be adding defamation to our complaint against them. They insist that they have not broken any laws, and they cannot control the actions of an individual employee who went against company policy, so we're at an impasse there. Either I move ahead against them, or I walk away. At this point, I'm ready to drag this through court. I tried to take the high road and go elsewhere, but they're regretting a lot that they've done to me without any action to correct it. Oh, I almost forgot. A few days after my last post, they sent me a packet of papers. Standard non-disclosure notifications, Consolidated Omnibus Budget Reconciliation Act, and a blank copy of the arbitration agreement for me to sign. Why a blank one, you ask? Well, it seems somebody messed up. They weren't making people sign when I was hired, and Human Resources never bothered to have me sign when I worked there. I, of course, have signed nothing that they sent me, including that agreement. I considered allowing arbitration if they pay the costs, and I have approval over who is selected, but my attorney has advised not to do that. I wish I had better news to report. Things aren't as hopeless as they'd first seemed, but not as easily fixable either. As for the employee who made the accusation, I know you're eager to hear, but at this point I can't comment on what's happening there. Thanks for all of the advice and support so far. I promise to update when everything resolves, if not sooner. As much as I can, update to everything has resolved, and I've been wanting to give you guys an update, but had to wait until my lawyer gave me the okay to talk about things. So let's start from the beginning. I pulled one of my direct reports, Deborah, into another room to discuss a few mistakes she made, but did not discipline her further. After this, she went to Joyce, one of the managers above me, but not in my direct line of report. Equal to my boss in terms of reporting structure. When Joyce heard that I had taken Deborah into another room without any witnesses, she said to her that it was unprofessional. Apparently her exact words were, "You know, you could accuse him of being inappropriate with you, and I would have no choice but to believe you." This was repeated several times, with a strong emphasis on no choice. Joyce then asked Deborah if I had been inappropriate with her, saying, "It will only happen again if you don't speak up now. If you do now, we can take action." Taking the not at all subtle hint from Joyce, Deborah accused me of indecent exposure to her, and I was placed on leave pending an investigation. Joyce immediately sent out an email that nobody besides the secretary was to speak with me without an attorney present, and told the information technology guy, Paul, to deactivate my access. James, my boss, had a resume from Terry, an employee in Joyce's department, applying for my job before close of business that day, and she was hired. Paul and I talked. He provided me with video proving my innocence. The company continued to stonewall me and refused to talk to me. When they did, they attempted to push me into arbitration and to retroactively sign an arbitration agreement. I cut my losses, took another job, and was ready to move on. Sandy, an employee in Joyce's department, broke protocol, talked to human resources at the new company, told them I had sexually harassed a subordinate, and cost me the job, so that brings us up to date. My attorney and I launched a civil suit against the company and Deborah. Bet you're wondering how I know the above. Well, good old Joyce said she'd protect Deborah if she came forward. Unfortunately, that only extended to her job. So when she was named individually in this suit, corporate told her they would not be providing her an attorney. After realizing that she'd be putting her house up for collateral, she was all too willing to throw Joyce under the bus. Joyce went to Paul, the information technology guy, who was one of her reports, and gave him a list of footage to be procedurally wiped as part of an archive clear-out. He pointed out that the incident with me was on that list and part of an ongoing investigation. Joyce told him that it was no longer needed and to go ahead and wipe it. He refused, citing the fact that it would still be requested in the event that the suit moved forward. She told him to pack his things as he was being terminated for insubordination. He called the company attorney and informed her what had happened. The aftermath, several things happened at once, so I'll try to keep them as chronological as I can. Deborah's attorney contacted mine, stating that, conditional on me dropping the suit, she would admit that she lied and explain what went on behind the scenes. Dana, the company attorney, got the call from my attorney with the details from Deborah shortly after she finished talking with Paul about him being terminated for refusing to destroy evidence. Deborah and Joyce were terminated for cause that day. Paul was told that his job was safe. My attorney received a call, and it was made clear that the company didn't want this to go any further and wanted to talk settlement. I won't go into all of the details, but what I can say, I was offered my job back with a very fair increase. I received back pay from the date of suspension, and a public apology was offered from the very top. Terry is now working in Joyce's old position. She's incredibly cool about things, and felt horrified when she found out what happened. James and I are good now, and he has personally apologized for not sticking up for me. This will likely be my final update. There is still some legal battle ongoing, but I can't go into that too much. Thank you for all of your support and encouragement. You guys rock. Story 3 won a lawsuit against a guy who tried to force me out of business because I broke his local monopoly. I am 26 years old, and I decided to open my own business this year. Moving forward in this post, I should point out that I am from a small town, 1,000 people in the rural Midwest. Because of this, everyone has some sort of connection with someone. We went to one of the liquor stores in the closest city 30-ish minutes away, small city 8,000 people. When we were grabbing some alcohol for a party, I was looking at the prices and saw how insane the prices were. For a 6-pack of a local beer, we were charged $15. I was thinking about this and figured that I could probably make bank opening a liquor store. Back in February, I was furious about my bad job and thinking out loud how cool it would be to own my own business to a friend. My friend's mom happened to be the president of the local bank. He told me, "Hey, with the pandemic, the bank has been struggling to find customers to give out loans. Right now, the bank is giving loans for cheap." A couple of weeks later, I went in and met with my friend's mom and pitched my idea with the research I had done on alcohol prices, potential demand, and estimated income. I got the loan at a fantastic interest rate. I bought a building, which happened to be the former bank, and hired my dad to help me renovate the building. My dad is a general contractor, and he gave me an excellent quote on materials and labor. After working everything out with the distributors, getting the proper licenses, and getting my paperwork I needed for the government, I was ready to open my liquor store in May. I had started taking out ads in the local newspaper advertising my store and my prices. When I was in talks with my distributors, I learned, even with inflation and everything else, the liquor stores in the city had like an 80% markup. I talked to a local business owner, and he suggested that I have around a 35% to 40% markup. Because of this, I was significantly cheaper than the closest liquor store, and had a much wider selection than the gas stations and small local stores nearby. My hometown is near a national forest. As such, we have a ton of people who come up for weekends for recreational activities year-round. My first week, the week before Memorial Weekend, after opening, I had made a $4,000 profit. It was great being my own boss. If someone was rude to me or my girlfriend, "Oh, I'm sorry, you can do your business elsewhere." If someone tells my girlfriend to go back to China and uses a racist slur, they can pay me 15% more at the register. Did the gang and I run out of alcohol? Time to grab my keys, not car keys, the store keys. My apartment is like 2 blocks away, and go to the store. That's not to say that it wasn't difficult running my own business, especially that my only employee was my girlfriend, and we were both working 6 or 7 10 to 12-hour days a week. I was both manager, accountant, and cashier, but heck, it's so much nicer knowing I can tell someone to pound sand for being a jerk. Couple of weeks after Memorial Day, some old guy walks into my store a couple of minutes after I opened. He seemed friendly enough, but eventually he offered to buy my store. I'm not going to say the amount, but it wouldn't have even covered my principal on the loan. I rejected the proposal outright and refused to negotiate the sum higher. He walked out of my store saying, "Welp, you'll be sorry you rejected that offer." The next month, a guy walked into my store and asked if I was the owner. After saying yes, I was informed that my business was being sued by this random guy they first never heard of for libel. After he left, I was freaking out, and I decided that I was going to close early. When I got home, I Googled the guy, and soon saw a picture of the guy that tried to buy my store. It turns out that that is the guy who owns both of the liquor stores in the nearby city. It also just so happens that he is on city council. With a little bit of further digging, I learned that this city has an ordinance that reads, "Any business institution that does not fulfill the definition of a restaurant, tavern, or liquor dispensary will be excluded from obtaining a license for the sale of alcohol." Later, I discovered that the same guy happens to be the head of the board which approves liquor licenses. I love small-town corruption. Either way, I had a major issue. My maternal uncle happens to be a lawyer in a neighboring state. I decided to call him and try to get some legal advice. I talked to him and read the documents that I had been handed served over the phone, and the research I had done. After receiving all of the information I had read off, I was expecting to get some sort of advice, but instead heard, "Hang on, I got to make a call," and he hung up. I'm freaking out. I was actually about to post my first post to the legal advice subreddit. I'll be honest, I just wanted someone to tell me it was going to be okay, and I didn't need to crawl to this guy on my hands and knees. As I was writing the title, my uncle called back. "Hey, original poster, I just got off the phone with my partner. He agreed that we can take your case pro bono. If you would like to accept, we can discuss at my office tomorrow at 1 o'clock. This is how I learned that my uncle is on the bar in 3 states. So we meet and we discuss the case. It turns out that the guy filed the libel suit against my business based on the ads I took out in the local newspapers. He claimed that my ads were targeted to damage his and his business's reputation. There were a few other things that I had no idea what was being referenced, but Uncle assured me that we would win this case no problem. 3 weeks later, the case is dismissed, but after my uncle says, people like that piece of work will likely try to file another suit against you. If that happens, call me and promise I will help. The next day I get served again, but this time I am the defendant. Not my store, me. I swear to God I look at the documentation, and the only thing that changed was instead of my business's name, mine is listed as the defendant. Same thing happens. 4 weeks later, the case is dismissed. Over the next 3 months, I was sued just as many times. Before the 5th case's hearing, we had a settlement meeting. My uncle, the judge, the guy suing me, his lawyer, a bailiff, and I were sitting in this room. Judge says, "You two have been in court 4 times already. Is there any way we could come to an agreement that'll stop this cycle of faulty litigation?" The guy's lawyer says they have an offer and hand it to my uncle, who then hands it to me. It essentially read that he'll stop all litigation if I sell my business for about 30% of remaining loan principal. I outright rejected the offer and made a counter-offer. I said, "If you drop this case, I won't sue your ass for harassment." He busts out laughing. "Sue me? With what money? The legal fees alone ought to have drained you. You should be happy I chose to extend this offer and not sue your ass into bankruptcy and buy that dump from the bank when the foreclose on your fool." The judge, the bailiff, and the guy's own lawyer were all looking at him aghast for saying the silent part out loud about the real reason I was getting sued. My uncle straight out said to him, "Oh, I am sorry. Apparently you were never told. I have taken all of my nephew's cases pro bono. The only money he has spent on your litigations is gas. And bluntly, sir, I think your outburst has just insured a suit against you." After that we just left, and I was then informed a few days later the litigation was dropped. Right now, my uncle and I are talking about the future suit against the guy. I want to sue the guy for a very high amount to try and get press attention on this guy and his sketchy actions. Although my uncle warned me that we'll need to be careful, because if we set the damages too high, it'll look like we're just being vindictive. This suit won't be pro bono, but after getting sued 5 times for free essentially, I am not going to complain. Looking back on this, I am so thankful that my friends and family supported the entire way, especially my uncle. Without my uncle, I would have absolutely lost my business. Relevant comment. Scarandonner, you're a very good writer. You might want to ask your uncle to have any future actions dismissed with prejudice, and your opponent named as a vexatious litigant. That's how this kind of thing is usually handled, not in a suit for harassment, and claims for damages usually come in the form of countersuit that is within the scope of the original litigation. That is by far the more economical option, and courts usually take a pretty dim view of original litigation that directly seeks to punish someone for filing lawsuits, which is a protected right under the U.S. Constitution and almost certainly under your state's constitution as well. Also, stay very close friends with your distributor. That's an easy way to cut your business off at the knees, especially if liquor licensing is handled at the local level. I'm really curious to know what state you are in. I always thought federal law required liquor licenses to be handled by the state, though local jurisdiction is usually allowed over issues like operating hours, etc. Your state also seems to have the most brutally efficient civil justice system I've ever heard of. Usually the course of litigation you describe would take years, not a few months, even before courts got backed up so badly with COVID. Original poster. Literally everything was dismissed in hearings before going to court by judges. I'm not exactly sure what the proper legal term is. Still, a couple of weeks of litigation can be hundreds if not thousands of dollars. Update. December 20th, 2023. This is a follow-up to a post I made last year. I'll link it at the bottom if you are interested, but the too long didn't read. Last year I opened a liquor store with my girlfriend, now fiancé, in my hometown. The nearby city had a few liquor stores run by a city councilman who controls who gets liquor licenses in said city. With me being 40 minutes away, he was losing business and offered to buy my store. I refused, and instead he tried to sue me for libel. His attempted for around half a year, continued to sue me, my business, or anything else he could, until it was thrown out with contempt. Fortunately, I was able to get my lawyer to take the case, pro bono, so I didn't get buried in legal fees as the guy intended. My lawyer and I then began to file suit against the guy, so that's where we left off a while ago. As of now, the case is over, and I can talk about it. So, to first explain why I didn't post any updates previously. When I filed the lawsuit, my lawyer was not to post anything about it online. I don't think that this had anything to do with the original post, but what he told me was that if the opposing counsel found a post and was able to link it back to me, they could argue that I was only filing a suit to gain online clout. But now the court case is over, so I can now talk to you guys. We filed the complaint about a month after the last case against me was dismissed. What we filed for was multiple accounts of malicious misuse of due process. After filing the complaint, we needed to serve the papers to the guy. Someone, I don't know who, must have told him, because he dodged getting served for multiple weeks. The only reason the process server was able to serve him was because there was a meeting to approve the transfer of a liquor license between two businesses in the city. Ironic, he and his lawyers answered the complaint and said everything in the complaint and the summons was a deliberate misrepresentation of the facts. None of the suits filed against me were in any way malicious, but given that the only thing that changed between most of the suits was the named defendant, kind of disproves that. He then went on to say that this current suit was simply a move by me to get revenge on him for trying to protect his business. Pretty much the entire answer was just him saying, "No, you." After that, we moved into discovery, which I will talk about in a minute. Through the discovery process, there were a couple of motions for dismissal by the defendant's counsel. The first was just a general, "All the facts are wrong, and this is a lawsuit filed in bad faith." This was immediately thrown out by the judge, because the four suits filed back-to-back with only the defendant being changed indicate that this was potentially a malicious lawsuit. A second motion was that these weren't malicious because the defendants were different. Effectively, the argument is that if the same defendant, then it would be a malicious suit. But because the defendant kept getting changed from suit to suit, that means that there was a legitimate complaint that they were trying to get solved, which technically would be legal, and I would have no standing. However, the judge acknowledged that while the argument is legally sound if you simply look at the wording of the law, it completely violates the spirit that it was written in, and the actions of the defendant only serve to confirm that the previous lawsuits were filed in bad faith. So, then the motion was tossed out of court. Later during discovery, the defendant filed for a venue change. Seems how we filed in my local court. They argued that the local jury would be biased towards me. This was dismissed because they forgot to ask for a jury trial. We were perfectly fine with proceeding with a bench trial, so we didn't ask for a jury. The judge decided then that because they didn't request a jury, a venue change would not offer any significant change in the trial. They used that decision, and some history I have with the same judge, to appeal to the state court to dismiss the case. They refused, so back to discovery. The whole process was extremely slow, and we were still in the middle of discovery when we decided to settle. We had received multiple settlement offers up to that point and rejected all of them. But at the end of November, the defendant decided to fire the manager of one of his businesses. The former manager then decided to turn over some text messages to the court. You see, we requested all communications about the malicious filings from last year that the defendant had made. That included text messages. That showed neither counsel nor the defendant did the proper diligence to comply with discovery. The defense was able to get that text removed from the evidence. While the text might not have been able to be used as evidence if had we proceeded to trial, you can't erase that you hid evidence from the judge's memory. They don't tend to take that well. With this coming to light and the chicanery that the defendant had been pulling, the judge was just over it at this point. Our lawyers had to meet with the judge at the very beginning of this month, December, where the defense's counsel was reprimanded. After this, the defendant offered a really big settlement. After my fiancé and I discussed it, we decided to accept the offer. Our wedding is getting close, and frankly, we don't want to deal with court stuff anymore. The whole trial process was still months away, and there wasn't any guarantee that we would have gotten any more money. Unfortunately, it's not the nuclear revenge I and my fiancé, and possibly you, were hoping for. Although the settlement, after I settled the contingency pay for my lawyer, did repay the remainder of my loan, we will have a nice chunk of money left over XR 171. Make sure you take steps to enforce and collect that settlement immediately. My spidey sense tells me he'll likely try to be a dick about it too. Original poster. Yeah, the settlement came through yesterday, which was what prompted the post. The first thing girlfriend and I did was pay off our loan debt. We're talking about throwing a nice little party for some friends and family for Christmas celebration. But that's still up in the air, and it's kind of short notice.